and I represent the Vice President and Senator Lieberman.
Mr. Boyce, let me start right off. When the case was here previously in the protest part of the proceeding, no counsel for any party in briefs or in argument raised with this court the U.S. Supreme Court case of McPherson versus Blacker, seemingly because counsel did not believe that it was important for our consideration. However, that case was forcefully argued to the U.S. Supreme Court, and the U.S. Supreme Court has now called that case to this court's attention in the opinion that came out this Monday. And now, once again, no counsel has argued that case to this court, but I want to know from each counsel its importance here. My reading of that case is that the U.S. Supreme Court has said that the state legislature has plenary power, full power, in respect to appointment of presidential electors, and that power cannot be eroded even by the state constitution. Now, accepting that as controlling law, why does that not mean that the courts of this state can only be involved in resolving controversies and contests where the legislature explicitly gives this court that power, or a court that power, which it has not done in respect to presidential electors in 102.168. And secondly, even if 102.168 is read to implicitly apply to presidential electors, why is it not judicial review given to the circuit court and not this court, since the only means by which there is a right to appellate review in Florida is through the state constitution? Would you please address that, and I would like the other counsel to address that.
Yes, Your Honor. First, with respect to whether the appropriate forum is the District Court of Appeal or is this court, the District Court of Appeal has, of course, certified this issue as a matter of great public importance and an issue that needs immediate attention.
I understand that jurisdiction. My question is appellate review, where that is not expressly given in 168.
We would say, Your Honor, that under 168, this court has the power to review both directly because it has been certified up and under this court's mandamus power, which we've also alternatively put forward in our brief.
Where is it? Where do we get our right to review the appellate review? From the rules and from the Constitution? And doesn't that create a federal question?
I don't think so, Your Honor, because what you're doing is you're reviewing and reviewing in an ordinary judicial interpretation way the statutes of this state. That is, I don't think the Constitution of the United States in any way means that the legislature has to sit both as a legislative body and a judicial body just because an election of presidential electors is involved.
Well, why isn't this like sovereign immunity, where courts only have such power to resolve disputes and claims that is expressly given to it by the legislature, where if the legislature in this state says courts are not to decide claims in excess of $100,000, those are matters that are taken to the legislature in a claims bill. Why isn't this analogous to that?
Because what I would respectfully suggest, Your Honor, is that the legislature has provided this court with the authority to interpret these laws. And whenever the legislature passes a law, what the legislature is doing is passing a law that is known to be going to be interpreted by the courts. That is, in terms of Section 168, this is a law that the legislature did not say we are only going to apply this law to non-presidential elections. Prior to this case, I don't think anyone would have contemplated that this law did not apply to presidential elections, and certainly no one, not this court and not either party, so contemplated the last time we were here before the court. This is a situation in which you have a statute that the legislature has passed that provides very specific remedies. And we think that those remedies are the remedies that this court has the jurisdiction to enforce, both in terms of appellate review and under its original mandamus authority. This is not a situation in which the Constitution of the United States has said a state legislature has to sit as a judicial body in enforcing the laws with respect to elections. It has merely said that the legislature can specify the manner of appointment of the electors. Incidentally, the manner of appointment, not the time of appointment. The time of appointment is something that is reserved for Congress. And we would suggest that Congress has set that time, and that time was November 7th. So
you would agree that when the United States Supreme Court has said that there is plenary power in the appointment of electors in the state legislature, that means that they've got full power?
Well, Your Honor, I think they have the plenary power to determine the manner of the selection. I don't think they've got the plenary power to determine the time of choosing, because that under the United States Constitution is reserved to the Congress of the United States. And the Congress of the United States has selected the time of choosing, which was November 7th. So I think there is a distinction between the time that the electors have to be chosen and the manner that they've been chosen. The legislature of this state, of course, selected the manner in which electors were to be chosen, and that manner was by direct election by the people. And pursuant to that decision by the state legislature and the decision by the Congress of the United States that the time of that selection was to be November 7th, there was an election on November 7th. And we think that is the issue that is before the court now, which is a contest of that election, where we have identified separately 5 groups of ballots that we believe either should have been received and were not, or in one case were received and should not have been, under specific Florida state law.
If we accept this, your jurisdiction, 168 in its present form has only been there since 1999. Now, this court said in 1981 that there's no common law right to contest votes, that judicial restraint should be exercised because of the fact that elections are political questions. We said in Borden right before that we would get involved, courts would get involved if there were allegations of fraud. Now, we lowered that threshold somewhat in Beckstrom by saying that we would get involved, courts would get involved if there was substantial non-compliance with election laws. But that aren't what you're asking this court to do, is to have the courts of this state get involved in any instance in which someone comes in and merely alleges that there needs to be a count because there were legal votes left out, not going through the canvassing boards, but legal votes left out. And then, that would have to do with election. Someone would say they lost 130,000 votes in Dade County, and we'd have to have the court count those votes.
Your Honor, I don't think that's what we're arguing. This is not a situation in which somebody has simply come in and said, we've lost, we'd like to have a recount under the contest statute. This is a situation in which we have identified specific votes, many of which were agreed by the district court, were votes in which you could clearly discern the voter's intent. You had 215 ballots that are not included in the certified results in Palm Beach County, where the circuit court found on undisputed evidence that there was a clear voter intent expressed on those ballots, and they were not counted. You had 168 ballots in Dade County that were counted before that county prematurely stopped its count.
For a moment, to Judge Saul's order, he makes certain findings. For instance, he finds that there was no credible statistical evidence and no other competent substantial evidence to establish by a preponderance or reasonable probability that the results of the statewide election in the state of Florida would have been different. Do you see that as a finding of fact or a finding of law?
Well, Your Honor, I think that it's a mixed question of law and fact to the extent that it relates to the factual issue. For example, at page 442 of the transcript, Mr. Amon, who was their witness, testified that you needed to have a manual review of the ballots. Mr. Burton, who was their witness, Judge Burton, who was their witness, testified that they were able to identify 215 ballots where they could clearly ascertain the intent of the voters that had not been counted by the machines. We have 9,000 ballots in Miami-Dade that are alleged that have not been registered by the machine that have never been manually reviewed.